Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
So look, interviews are not supposed to be adversarial. They are meant to gather complete and accurate information, whether it's favorable to you or unfavorable because of something that makes you inadmissible to the United States. It's to properly adjudicate the case, they need to get accurate information. By they, I mean the officers. Now, under Trump, the interviews are harsher. They are more confrontational than they used to be. Again, officers are different, but newer officers have tend to be a little more confrontational than they were in the past. Some officers are friendly and a matter of fact, but increasingly they're more businesslike. Sometimes they're rude. Sometimes they're just stressed and they come off as being rude. You should prepare as if it's going to be an adversarial and confrontational officer. You know, come mentally prepared that this is going to be hard, that they're going to give you a hard time, that they're not going to necessarily believe you. That may not actually be the outcome, but I always tell my clients, you prepare for the worst, you hope for the best, not the opposite. And you can and should prepare. Your attorney's most important role is to prepare and review your situation before your petition is filed and before the interview happens. That way, if there's something in your past that can result in a denial, and today denial means removal of proceedings, you know about it in advance. There are no surprises. In the past 2 months alone, I've met 3 different families that went in, they either filed a petition on their own, or sometimes they did it with counsel. In one particular situation, they did it with a now disbarred attorney. They went into the interview and the immigrant was detained by ICE. Why? They had an order of removal. They did not know that was going to happen. They were not prepared for that to happen. It's incredibly important you speak with a qualified immigration attorney before you file and definitely before you go to the interview. Now, if you don't have maintained copies of your documents, then the attorney's role before the interview is going to be limited if he or she did not fill out your documentation. Your attorney is there to encourage that the officer remains professional and courteous and sticks to relevant issues. When the officer doesn't, your attorney, should request a supervisor to put a stop to the inappropriate conduct. I've done it on a number of occasions. I don't like to do it, but when someone's out of line, I do what I got to do. The officer is going to ask lots of questions. Sometimes the questions can be vague or unclear. So my role there is to make sure that you understand the question and you're answering it as honestly as possible. If the officer asks one thing and you answer something else, I may say, I'm sorry, I don't think he understood your question. Can you repeat it? Again, that's my role. It's not, listen, you fool, what are you doing? That's not what the attorney's role is. I'm there to make sure that to help you give the officer accurate information so that they can adjudicate your case. Attorney can't answer questions for you, nor do they ask you direct questions like in court. My role is to make sure the record is clear, that the questions are straightforward, so USCIS can make the right decision based on the information. Look, as long as you've been honest with me, if you're at the interviews because I believe you can be approved. Otherwise, I don't put you in that scenario. I don't file. I will tell you, and I have, I'm sorry, I can't help you. Even if you give me $10,000 cash, here's the money back. That's, I can't accept it because you're inadmissible for this reason. And I would never advocate that you lie about it. Having an attorney does not mean you have something to hide. Rather, many USCIS officers actually prefer applicants to have attorneys because they know the interview will run smoothly. So it depends on the officer. Some people see the attorney as a hindrance for their ability to get to the truth. Others see us as a positive because it means that the client is prepared, the information that they need is there, and it makes their life easier. Now, a good attorney is thinking about what does the officer need to approve it. A bad attorney is thinking, what's the minimum I can do to file this case? World of difference between those two scenarios. Most of my clients, we prepare a book. It's massive, 200-300 pages. Officer doesn't always like to look through all of it, but they know that the information that they need to decide, I've provided it. When do you get your decision? So increasingly, officers are not making decisions at the interview. they often say, well, you know what, the background searches haven't come in yet. Or I need certain documentation about X. Let me give you an example. About 3 months ago, had a client entered the U.S. at a port of entry, presented herself, said, listen, she made a claim for asylum. She actually went to the port and said, hey, I'm filing for asylum with my infant child. So they were processed, they were released. 3 years go by. She meets a nice guy. They get married. He's a U.S. citizen. She wants to file for him. She's in removal proceedings. So higher burden of proof. Now they didn't separate them in this case, but when she initially met an officer at the border, the asylum officer, when they did what's called the credible fear, we talked about that on a separate episode. They said, okay, you're claiming asylum. Do you have enough information? Do you have to meet the criteria where you might be able to prove a case for asylum? In her case, they said yes. They let her in. But in that interview, the officer says that they asked her, are you married? And she said, yes, I'm reuniting with my husband and the father of my child. And at the interview, they asked her, so at the interview for the green card process, they said, well, were you ever married before? She says, no. Are you sure about that? She says, yeah, I'm sure. I know that I was never married before. This is the first time I was ever married with this guy. Well, so takes out a statement saying, well, you told so-and-so at this time that you were married. And her response was, I don't know why the officer said that. He asked me, did I know anybody here? And I said, yes, the father of my child is here. But she said, listen, he's a drunk and it didn't work out and I left him. It was a danger to my son and to myself, so I left. But I was never married to him. And it was very clear that I was never married. So the officer there couldn't make a decision. He had to go and say, you know what, I need to figure out what or how, what happened there, translation. He needs to go and listen to the recording if it's still available and see what was said and what was asked. So in that scenario, the officer could not make a decision because they needed more information on an important subject. Because for the simple reason is if she was married before, then she needs to either be divorced, or he needs to have died and has a death certificate in order for her to be able to remarry a U.S. citizen. If she was never married before, then there's no legal impediment to that marriage. So officer could accept, officer could deny, officer could need additional documentation, or either way, they'll give you a notice saying, I'm sorry we couldn't make a decision on your case today, or because we need the following, or we're reviewing the following. They don't usually give a reason. But within 60 days is typically when you get an answer. It should be a lot less than that. If you liked what you heard, subscribe, give us your comments. Any questions you have, happy to answer them to the best of my ability. Until next week.